Good morning, everyone. I just want to welcome everyone. I just want to thank everyone for coming out. The Young Lawyers Conference of the Virginia State Bar kind of gave me free reign to put this on. So I hope you guys enjoy the program. I thought it'd be a good opportunity to have some live CLE credits that were kind of local, so you didn't have to travel a long way before the deadline comes up. Our first speaker is Bary. He's been at my firm, my dad's firm, for a really long time, and I just want to thank all my speakers. They kind of put these programs together in less than 2 months, so they've been really helpful and great. So without further ado, I'll let David start.
Good morning, everybody. Just go ahead and stay asleep, and I'll try and get in and out as quick as possible. But I appreciate having an opportunity to speak a little bit today about Social Security disability, since it is a fairly active practice of law in our area. And I'm not going to put anybody on the spot, but I would like just to have an idea, just by show of hands, who here has at least handled a Social Security disability case? I see some familiar faces. Okay. Is there anybody in here that hasn't handled a Social Security disability case? And okay, and you're possibly interested in handling it, or you may have that come up in your practice at some point in time. All right, well, I'll try and stick with the basics. We may get in depth a little bit. I'll also be happy to take any questions, so you all don't have to listen to me drone on and on for an hour. But for anybody that has practiced Social Security, even if it's just been a handful of cases here or there, I'm sure that you understand that there's been a fairly significant change in the landscape of Social Security disability law, especially in the last 3 to 4 years. There's been quite a bit of scrutiny that has now been placed on the Social Security Administration as a result of some things that happened back in 2013. And just if anybody wants, I'm not going to really get into it, but if anybody is interested in reading or trying to get an idea of why things have changed, why it is much more difficult to be successful with the Social Security disability case, it kind of started with a congressional inquiry and investigation. And I'm going to put it up here at the table if anybody wants to browse it during the break. But just to give you an idea, the title of the staff report was How Some Legal, Medical, and Judicial Professionals Abuse Social Security Disability Programs for the Country's Most Vulnerable. So that's here. I'm going to put it right here. So in light of that, back in 2013, quite a bit of scrutiny. ALJs, judges that preside over Social Security disability cases, started having their actual decisions pulled and reviewed. Their allowance rates were reviewed, and really what happened is that your ALJs that had pay rates of over 60 to 65% really got a hard look. They kind of got their wrists slapped at times, decisions looked at, comments made, and they even, maybe not by name, but at least their decisions in their hearing offices were referenced throughout that congressional report as well as subsequent reports. So, what does that do for the practitioner? What does that do for your client? What things have to change? What things do you now have to look for in order to be successful? And to be quite honest, this is somewhat of a funny story, but I've been practicing for the past 16 years, and I can recall when I first started back in 2000, 2001. That there would be times that you could attend a Social Security disability hearing, and that hearing would last 5 to 10 minutes. You'd be in, you'd be out. 2 or 3 weeks later, your claimant probably would receive a favorable decision. That's not helpful to the system. I mean, that may feel good to come away with a win, but all in all, that's not helpful to the system. And in fact, that's probably what created or helped create what happened in 2013 in regards to things really starting to change. So with this, we now have allowance rates that have dropped. National allowance rates before 2013 at the hearing level probably were approximately 65%. Pretty good. The allowance allowance rate currently at the hearing level is about 48%, 47, 48%. Most of your judges, where you enjoyed an allowance rate over 60, 65% with a particular judge, you're lucky if they're 50-50 now. That's the other thing that I have. And you can access this online. Some of you all that practice Social Security disability probably already know this, but the government does now put out ALJ disposition data. It runs the names of the judges, and it takes for the printout that I have here is for the fiscal year 2016, which would be from September of last year up through August of this year. You can get online if you have a particular judge that you know that you're going to appear before. You can actually get online, pull that down, and see what their allowance rate is. I'm going to set this up here too if anybody wants to browse later. May have a particular judge in mind. You want to see what their pay rate is. It would be in there. Also, in the last several years, in addition to some of these problems and the allowance rates dropping, the Social Security Administration has also moved to video hearings. You no longer, very rarely, are you in a room with a live judge unless you're at the main hearing office. For our area, main hearing office would be over at Kingsport. At least if you're over towards Scott County and that side. Now, this particular area in Wise, we now go through the Roanoke, Virginia hearing office, and those are video hearings. Those hearings are held at the district office up in Wise. And although you get used to it after a while, still there's some things that you miss, or I think that a judge may miss not having the benefit of being there live. So that's another issue that we have to deal with. Another big change is in regards to the submission of evidence. There has been a recent change in regards to the submission of evidence. And the best way that I can sum that up, one, I'll give you the code section. I don't think it's in actually, I don't know if anybody has the materials or if the materials were emailed. But it's 20 CFR 404.1512, 1512. That's the new rule in regards to submission of evidence. In the past, before this rule became final, as a practitioner, as an attorney, you did have some discretion in regards to the medical evidence that you could submit on behalf of your client. Prime example, there's one thing, we try and get opinion evidence from a treating source. We call that a physical assessment form or mental assessment form. Basically a RFC form, which is a residual functional evaluation. If you sent that out to a treating source and you got it back and it wasn't necessarily favorable or supportive of your case, you could argue that that was work product, that was a subjective opinion from a treating source, and you didn't necessarily have to submit it. Of course, if you were asked by a judge or it came up, at that point in time you may have to submit it, but it wouldn't just have to be an automatic submission. That's something that many times, if I had an unfavorable RFC form, I would not submit that RFC form. Also, in regards to treatment notes, in certain cases, emergency room visits or things like that may have not been helpful, possibly evidence that was not submitted on behalf of your client. You can no longer do that. With this evidence rule that I just cited, it now requires you to basically submit, and I'll just read from it, submit all evidence known to you that relates to whether or not you are blind or disabled. And if you don't submit it, you're also under a duty to at least let the court or the judge know that it's out there. Meaning that if you're aware of an emergency room report or you're aware of some type of hospitalization or your client has been somewhere for treatment, even if you feel that it's not relevant, even if you feel that it might not be favorable, you at least have to let the judge know that it's out there. And as I mentioned, in regards to assessment forms and trying to claim that it was some type of work product, the rule actually, specifically references that any type of assessment form, as far as medical evidence, medical source opinions, are not considered work product. So that makes it tougher as far as being a practitioner or handling Social Security disability cases as far as evidence submission goes. So one of the issues is how do we address that? How do you deal with that, just as far as a practicing point? There's one thing that we found that can be helpful in regards to the issue of what do you have to submit or having to submit everything. And first off, I just want to make sure everybody's clear. When I say a RFC form, I don't know if everybody has seen the RFC form or you're familiar with it, but an RFC form is basically a 4 or 5 page document which asks the examining source specific questions. Lifting, carrying, sitting, standing. If it's a mental assessment form, it asks questions about focus, concentration, being able to carry out detailed job instructions and the like. That's something that we send to treating sources to have them complete, which we then forward on to the hearing office or forward to Social Security. That gives concrete examples or concrete restrictions or limitations as to what your client cannot do. And like I said, now if I send one out, it comes back, it's not favorable to my client, I still have to send it in. So what do you do to try and combat that? And the question, or the issue is, or what you can do, rather, is if at all possible, one of 2 things. One, talk directly to the treating source if that's a possibility. Any conversation that you have with the doctor or anything that you talk to with the doctor is not anything that you have to submit. It's just a conversation. So if you can, try and reach out to the doctor, see if you can't kind of peg down things as to what that doctor may feel your client may or may not do. If that's not a possibility, have your client talk to their doctor. Let the client say, hey, go in and have a conversation, explain to them that there's a disability claim pending, ask them what kind of restrictions or what kind of things that they think that they might be able to do or what they can do. If you get a positive return from your client as far as the discussion with their doctor, then go ahead and send them an assessment form and have that assessment form completed. But that is one of the really tricky things, especially here in the last 12 months that we've had to deal with. Also, not even I'm talking about right now is just with evidence, and that's presupposing that your hearing is ready and you're able to appear. The backlog of cases at the hearing level has led to an enormous wait time as far as from the time the file gets to the hearing office to the time that a hearing is actually scheduled. And that is something else that you can also get and pull down in regards to the wait times. And I've got that. I just want to give you a couple examples as far as what we're dealing with in our area. The Roanoke hearing office, which as I said does the video hearings there in Wise, their average processing time right now is 582 days. So that is 582 days from the time that the file is received at their office to the time it's worked up and to the time the hearing is scheduled. So that's 582 days that your client is going to go without any type of benefit and most likely any type of medical coverage, unless they've been lucky enough to possibly get coverage under this Affordable Care Act, which it seems to me, more so than not, we still have a lot of clients that don't have any type of hospital benefits or insurance. Kingsport. Kingsport is a little better than Roanoke, but still Kingsport's average processing time is 454 days. So as you can see, that's an extremely long wait. And also, as a result of that wait, there's other issues that now arise. We have clients that, after they've waited 9 months, 12 months, into a year and a half, you have some times where your client will try to go back to work, whether it's for a period of time, just a few days, a few months, or they may try and go back and stay there for 6 to 9 months. It varies, but that's an issue now also that we have to deal with is work that is performed after the alleged onset date of disability. A couple other things as far as some changes. Anybody that's done any type of Social Security here recently, the file, everything is now electronic. If you want to do, or you're planning on handling maybe picking up some Social Security cases, you will have to go into the hearing office over in Kingsport and register to be able to get access to your file electronically. In the past, the hearing offices would provide a copy, give you a CD. You go into the ODAR, into the hearing office, you get a CD. That stopped. As of I think last month, maybe here in the last 2 months, they will no longer provide representatives a copy of the file, in the sense that they will give you a CD. You'll have to have a password, you'll have to have electronic access. Now, that's problematic, but one other thing, is that if you don't have the electronic access, they're not going to withhold your attorney fee. So what happens then, if you're not set up for the electronic access, you win the case, what typically happens is that your attorney fee is withheld, released to you, past due benefits are released to your client. If you're not set up electronically, and you go in without that, then basically they'll just release the withholding of your fee to the client, and then in turn you'll have to try and get that fee from your client. So that's something else that you want to keep in mind. So it's really important that you do that. 2 forms that need to be filed to be able to get direct payment. That is, the first form is the SSA 1699, which is a request for appointed representative direct payment. The other form is the SSA 1695. Now that 1695 has to be submitted for each case, for each client. A 1699 pretty much is a one-time submission, but the 1695 has to be submitted with each case. Failure to do that will also result in your attorney fee not being withheld, and the attorney fee will go directly to your client. So those are some of the basics. Those are some of the changes. And again, kind of getting back, what can we do as attorneys to help our clients, to maximize our client? You know, with Social Security disability, in regards to what the benefit amount may be, there's really not much that we can do. That benefit amount is basically set based on earnings, meaning that whatever that client paid in while they were working, the benefit amount is calculated off of that. So there's not much that you can do as a representative that you can do with that. However, one of the things that happens quite a bit now is that many of the judges want to manipulate or want to change the onset date of disability. Meaning that whereas you may have your client alleges that they became disabled in December of 2013, when you get to the hearing level, lots of times these judges nowadays want to use May of 2015, or they might want to use a date 2 or 3 months ago. All right, what does that do? Well, that has a huge impact on your client because basically the past due benefits are just going to be eliminated. And for somebody that has gone 1.5 years to 2 years without any type of benefit, that can be pretty detrimental. And it also can be harmful to your practice because also when the past due benefits go away, so does your attorney fee. So it's very important that you take steps to try to protect or ensure that the alleged onset date is supported by medical evidence. And the way we do that, the way Social Security does that, is that everything is set up on what's called a sequential evaluation process. It's a 5-step process. And I've had, at times I think we've kind of gotten away from it, but here recently I've had judges even tell me that they appreciate the attorneys that try and set things up and structure things off of the sequential evaluation process. And it's not that hard. It's just that sometimes we just kind of overlook it and just go in and make a few comments about medical evidence or make a few comments about what our client can do and can't do, and then just go on with the hearing. But let me go through the sequential evaluation process. And I don't know if anybody's got their materials or anything, but let me. It's all that. If you have them emailed or whatever, if you have access to your materials, it's the sequential evaluation process is in there. The first question is pretty basic, although it used to be basic, and that is your client engaging in substantial gainful activity. Okay, what's substantial gainful activity? Well, the government considers that to be activity that's both gainful and substantial, but they put a dollar amount on it. For 2016, for a non-blind individual, the substantial gainful activity level was $1,130. Now, what does that mean to you? If you have a client that comes in that's working part-time or that's still working, to evaluate the case, you have to make a determination, okay, if they're working, how much? And that $1,130, that's not net, that's gross. If they're over that $1,130, then they're basically engaging in gainful activity and they really don't have a basis for a disability claim. It's not so much that you have that at the outset. What I said earlier, the problem that we're having now is that you have these individuals that have to wait forever and forever and forever for benefits that will try and do something and go back to work. So at that time you have to kind of make that decision or you have to evaluate that and see what can you do. So quickly, because I know I'm probably dragging, but with step one, with substantial gainful activity, there's a couple things that you need to look at. One would be the nature of the work, especially if you have a case. Let's use this as an example. I have a client whose case is pending up at the hearing office in Roanoke. The case has been at the hearing office at least for 12 months. Plus you have to add in another 9 to 12 months that it went through the initial process and the reconsideration process. So my client calls me and says, hey, I'm trying to do a little bit of work. My friend down the street contacted me and I'm doing some work. So what you need to do, first thing you need to ask one, how much? What are you being paid? Not net, but gross. You have to tell that your client automatically, start keeping track of check stubs. You need to find out what the nature of the work is. Because there are a couple things that you can utilize. One is what's called an unsuccessful work attempt. And there is a Social Security ruling that provides guidance and that is helpful. The Social Security ruling is SSR 8425. And for what it's worth, in the materials, the website to be able to access the rulings is in the materials. The rulings, it's the large body of rulings. They're grouped by year. They can be very helpful. The rulings cover a variety of issues, from non-medical issues to work issues to medical issues. And I've got there's quite a few rulings in the material that I have found helpful over the past 16 years. So, an unsuccessful work attempt. What is it? An unsuccessful work attempt is when an individual goes back and they try to work and that period of time is less than 6 months. So if you have a client that at some point in time while the claim's been pending has gone back to work, they've only worked 3 or 4 months, then what you have to do is that you argue that that's an unsuccessful work attempt. What happens, if the judge finds that that's an unsuccessful work attempt, the case can continue. It's very important that you understand how to utilize an unsuccessful work attempt argument. The other thing is work performed under special considerations, special accommodations. Some people call it sheltered work. And what that is that you have individuals with certain type of disabilities that are allowed to work in some type of sheltered workshop, meaning that they don't have to work as many hours as a typical employee. They're provided extra breaks. They're provided a job coach. They got the job because of a friend or family member. Maybe they require additional assistance. Those are things that you also need to inquire about when your client calls you and says that they're trying to go back to work. Work that's performed under special accommodations or special considerations is not considered gainful activity. That's the trick there. You have a client, like I just said, the gainful activity level is a little over $1,000. Let's say they're making $2,000. They're over the SGA level, but it's work that's performed under special considerations. Case can continue. So that's another thing that you need to be mindful of. That's step one of the sequential evaluation process. And honestly, before in the past, years ago, that's really something that never really came up. You know, your client either was working or not. And basically you went in and tried to put the case on and that was it. But now, because of the length of time, we really lots of times have to address work issues after the date of disability. Step 2, is the impairment severe? All right, now this doesn't mean disabling. Basically, it's just a question of whether or not the impairment is severe. Social Security defines a severe impairment as one that significantly limits an individual's physical or mental abilities to do basic work activities. That's severe. So if the impairment is found to be severe, boom, you go on to the next step. That's typically not a hard thing to do, but it's very important that any impairment that your client feels contributes to an inability to perform any type of gainful activity, you need to make sure that you get that medical evidence, that you track it down. All right, step 3. Step 3 is, does the claimant meet or equal a listing? I also give the site in the materials in regards to how you can access the listings. The listings are basically grouped in about 15 different areas, and they're broken down by body systems, as far as certain types of conditions and things of that nature, for like the spine, disorders of the spine, mental health issues. All those are broken into certain sections. And under that particular section, there'll be multiple listings. To give an example, as far as the issues of the spine, there'll be a listing regarding the cervical spine, the lumbar spine, problems with the hip, problems with any type of weight-bearing joints, things of that nature. What the listings do, the listings basically are your black letter law, meaning that if you have a client that meets that particular condition as it's laid out in that listing, word for word, you win your case, you prevail. Now that sounds easy, but until you, once you go and try to sit down and you read the listings, you realize how restricted the listings are. It is very tough to have a case where you actually meet the listing. Now, one thing that I think sometimes we lose sight of, though, is that on the flip side of that, there's also what's called equaling a listing. And that's where it can get a little tricky. And basically what equaling means is that if you have an individual, you have a client with multiple impairments, that would result in the medical equivalent of the requirements set forth in one listing, and they equal it. And what I mean by that, if you have somebody that has 3 or 4 different types of medical conditions, but you bind all of them up, and because of that, they would actually equal a listing, meaning the level of severity would be the same, you prevail. That listing is found to be equal. You have a much better chance of equaling a listing than you do meeting a listing. But here's the catch. If you're at the hearing, the only way that you can find that a listing is equal is through testimony from a medical expert. So what you have to do, another practicing tip, if you're going to a hearing where the judge, and you can take a medical expert with you if you want. I mean, I think it'd be way too costly to do that in this type of setting. But if the judge has not called or does not have a medical expert there to testify, you really can't make an equals argument. You can't say, okay, judge, my client has a herniated disc, they're diabetic, and they have a bipolar disorder. And if we wrap all this up, listing 104 is going to be met, or I'm sorry, equal. You can't do that. You have to do that with medical expert testimony. So what you need to do, we have a thing in the office that we call listing letters that we'll send out. We don't do it as much now because of the changes to the submission rules. But we have listing letters. We'll take that particular listing, or if it's more than one listing, we'll put it in a letter form. We'll try and make it as easy as possible for the medical provider to be able to look at it, to review it, and then give us an opinion as to whether or not that listing is equal. And you have to go that route. If there's not going to be a medical expert there to testify at the hearing, you've got to go that route if you feel that you have an equals argument. Did anybody have any questions? Okay, good. Step 4. So if you don't meet or equal a listing, you move on to step 4. Step 4 is, can the claimant perform past relevant work? All right, what's past relevant work? That is work that the claimant has performed within the last 15 years and has lasted long enough for him or her to learn the job and was performed at a substantial gainful activity level. So basically, what does the government, what does the Social Security Administration look at as far as past relevant work goes? Work that was performed the last 15 years. Anything that was done 20 years back, or anything they did as a kid or as a young adult, teenager, it doesn't really count. This, at step 4, it's very helpful to know how to cross-examine a vocational expert. Like I said, you may not always have a medical expert at these hearings, but if you have an individual over the age of 18, there will be a vocational expert present to testify. Now, the role of vocational expert is twofold. First off, the role of vocational expert is to identify or classify past relevant work. So part of the hearing, your client is going to, by answering your questions or questions that the judge may ask about their work history. What did they do? What were their job duties? How much did they have to lift and carry? What level of focus and concentration did it require? After the direct testimony is offered by your client, the judge will then turn to the vocational expert and say, okay, Mr. and Mrs. Expert, can you classify the past work? That expert will then put the past work into an exertional category and a skill category. The exertional categories range from sedentary work up to very heavy. And just a brief snap as far as what those levels are. Sedentary, we're talking about 10 pounds occasionally, 5 pounds frequently, being able to sit for the majority of an 8-hour workday. Light duty work, 20 pounds occasionally, 10 pounds frequently, being able to sit, stand for 6 hours out of an 8-hour day, being able to stand or walk 6 hours out of an 8-hour day. Medium work, 50 pounds occasionally, 25 pounds frequently, being quite active, basically on your feet most of the day. And then you have heavy, very heavy, that's when you get upwards over 100 pounds. But typically in our setting, what we're dealing with is medium, light, and sedentary. And, you might have to deal with a heavy exertion. Not the fact that you don't have clients that work heavy exertion, but typically even the lower levels, the state agencies, usually knock heavy exertional work off the table. And what you're left with is medium, light, and sedentary. Now, what's the need or what's the concern as far as past relevant work? Sometimes I have clients that think that they're doing themselves a benefit when they go in and they minimize their job duties, or they minimize what they had to lift and carry, or what the physical components may be. And sometimes they think that, well, if the judge understands I wasn't really able to do much to begin with, then the judge will understand, hey, I'm in bad shape. And that's not the case. So be sure that your client understands that it's not helpful to sugarcoat their past work. And that's why it's very important before the hearing that you inquire and you have a pretty good idea of what your client did, what the past work was, what the nature of the work was, from how long they were on their feet to how much they had to lift and carry. Now, if the judge finds that your client cannot return to their past relevant work, we take it to the next step. And the next step is there other type of work? Can the claimant perform other type of work? Now, that has to match up with the residual functional capacity of that claimant, and it also the jobs have to exist in significant numbers in the national economy. So, one thing I want to talk about, this part's not in the materials, but is anybody familiar, just by show of hands, is anybody familiar with the Dictionary of Occupational Titles? I mean, that comes up not just in the Social Security setting, but even with the PI, automobile accident settings at times with vocational expert testimony. Anybody familiar with the DOT? Right. All right. Well, let me give you just a quick background on the DOT. The DOT is a dated publication. It was last updated in 1992. But it is the Bible that is used by these vocational experts to identify other types of work. And matter of fact, if anybody's handled the Social Security disability hearing, as soon as the vocational expert provides a job, the very next thing that the vocational expert provides is a DOT number. And the DOT is a publication. It has jobs that are grouped by exertional level, skill level, and things of that nature. So a couple things that you need to know. we talked about as far as the exertional levels. The other thing is what's called SVP, and that's just an abbreviation for specific vocational prep factor. Okay, and I know, and I'm sorry, I don't want to get super technical. What's an SVP? SVP is just basically how long it takes a person to learn their job. And that's what they use as far as the determination as whether or not it's skilled work or unskilled work. An SVP of 1 or SVP of 2 is unskilled work, meaning that that individual, your client, can learn that job with a very short, brief demonstration within a 1 to 2 month period. If you get into a SVP or you get into skilled work of a 4, 5, or 6, that means that takes that individual much longer to learn the aspects of that job. Now, why is that important? Well, the reason why that's important is that sometimes you'll have a client that has a certain type of mental health limitations, or you have a client that suffers from a great deal of pain, either from some type of spinal impairment or some other type of condition. Lots of times we forget and we think that pain can only be limiting as far as sitting, standing, walking, lifting, and carrying. That's not the case. The government also recognizes, Social Security recognizes, that pain can also limit concentration, focus, your ability to carry out detailed job instructions, your ability to deal with typical stressors and norms in a regular work environment. So, let's see the best way to explain this. When I said that when the judge asks questions of the VE, that's done in the sense of hypothetical questions, meaning that the judge will pose a hypothetical question to the vocational expert, which goes something like this. Okay, Mr. Expert, can an individual, same age, education, past work history, as the claimant, who suffers from, who can only lift 20 pounds occasionally, 10 pounds frequently, sit for this long, stand for this long, use their hands in this manner, can that individual return to their past work? The next question is, okay, if the person can't return to their past work, are there other types of jobs that individual can do? And that's when that vocational expert either is going to say no, based on those limitations, there is no work that exists, or yes, there are jobs, and here's the jobs. So it's your role as your client's attorney is that you didn't have to be able to cross-examine that vocational expert. And one of the things that can come up is how they classify the skill level. Because, again, what we have here is a dated publication. I have a vocational expert that will identify a job, an unskilled job called Government Surveillance System Monitor. Okay? If you look in the DOT, that's an unskilled job. And if you look a little further in the DOT, you learn that the last time that publication actually went in and looked at that job to see what the job duties were was 1977. So what does that mean? We've had a lot of changes, a lot of innovations since '77 in regards to things as far as computers, technology, things of that nature. So if you have a judge that gives a hypothetical saying that your client cannot perform at a skilled work level, and you have a vocational expert that identifies a government surveillance system monitor job, which in an old dated publication was last updated in '77, it would be very helpful to be able to cross-examine that vocational expert in regards to the changes that have happened and taken place over the years with that job, to the fact that that job is no longer unskilled, but it's a skilled job. And lots of times you can have those experts agree with that line of questioning. What effect does that have on the case and on your client? That job's eliminated. If that job then goes from unskilled to being skilled, and the judge has accepted the fact that for whatever health issue or condition that your client has that they can't perform skilled work, that job's eliminated. So that's why it is extremely important that you understand a little bit of what's going on as far as with the DOT. One other quick thing. Let me, I've got the listing or the site for the DOT. You can pull it up online if you want to take a look at it. It's available online. It gives you a job description. It gives you its DOT number, it gives you a job description, and at the bottom it's a trailer, or what we call a trailer. which lists several things. One is the strength level, like I said, sedentary, light, medium. One is the skill level, the SVP. But another one, and this is just a quick practice tip, another one is called the GED levels. Now, the GED levels, it's not in the sense of GED levels like high school or anything like that. The GED levels basically are broken down into 3 areas. Mathematical, language development, and reasoning. And this is just, like I said, this is a quick tip. If anybody has done this at least just a little bit, you're eventually going to bump up with a client who has a great difficulty being able to read or write, maybe functionally illiterate, or has some type of difficulty like that. If they do, if you don't properly cross-examine a vocational expert's going to find jobs for those type of individuals. But if you look at the GED levels that's contained in the DOT, you have some requirements that kind of run counter to that. Just a quick example. The base level language requirement for any unskilled job in the Dictionary of Occupational title requires that the individual be able to read at a rate of 95 to 120 words per minute, and also be able to recognize the meaning of 2,500 2 to 3 syllable words. That's not an individual that I would think that's functionally illiterate, that does not have the ability to read. Something as simple as that, but although it's out there, you have to kind of dig for it, can make all the difference in the world to your case. Lots of times judges will listen to those arguments. So if you have a vocational expert who is given a hypothetical question where they said the individual can't do simple math, that they're unable to read or write, and then you have a vocational expert that identifies a laundry list of jobs, you can always come back with that as far as with the GED levels and the requirements. All it takes is just to have it handy on you when you go into the hearing. But something as simple as that can be really effective. I know I'm almost done with time, so I want to jump over to one thing real quick. Another thing that can be helpful to your clients, it can maximize as far as your past due benefits with the client. It's called the Medical Vocational Guidelines. We call them grids for short. The reason that they're called grids is because there's 3 tables that appear in the Social Security Act and the Code, and those grids are set up based on several factors. They're based on age, educational background, work experience, and then whatever your client's functional capacity may be. And I'm going to show. I don't have a fancy PowerPoint presentation. I'm kind of a little old school, but this is what the grid table looks like, and that's why they call it a grid, is that's basically what it is. It's set up like, for example, table number 2 is maximum sustained work capability limited to light. So if you have an individual that's already been limited to light exertional work, you plug in their age, you plug in their education, you plug in their previous work experience, and then it tells you whether or not they're disabled. That's basically the grids. The grid rules can be very helpful if you have an individual that's already at age 50 or above. So you definitely want to be aware of the grid rules. You want to utilize the grid rules if you have a client that's 50. And the rules actually ease up even more at the age of 55. So how do you do that? A couple things that you need to know in regards to using the grid rules. Work experience. There's usually two things that come up when we're dealing with the grid rules as far as problems or obstacles that you have to overcome. One is the work history. Okay, like I said, I used that table, light work or sedentary work. If you have a client that's age 52 with a limited education, but let's say they worked as a receptionist, or let's say they worked on an assembly line sitting all day taking toothbrush boxes and packing them in a box. That's sedentary work. You have to be able to eliminate that work for the grid rules to apply. So in order to do that, you have to have a good understanding of what the work was. You have to be you have to have an understanding of whether or not there were other type of job duties that your client may have had. One other thing is that, which isn't widely known, is that Social Security follows a rule called a composite worker or a composite job rule. If you have an individual, let's say a client that performed 2 or 3 jobs, which kind of all got lumped into one particular job. Some of the job duties were sedentary work. Some of the job duties were light or medium work. What effect does that have? Well, if you argue that it was a composite job, and I've got I think it's in the materials, but there's a rule in regards to that. A composite job requires that the judge or the Social Security Administration has to take the highest exertional level that job was performed at. So meaning if your client for a couple of hours of the day did nothing but sit and push papers, but then 2 or 3 hours out of the day, let's say they had to go out and they had to do some landscaping work, or they had to clean a certain area where they were lifting in excess of 25 pounds, they were on their feet. What you get to do is that job becomes a light job, moving your client's past work history up the chart so the medical vocational guideline can apply. So it's little things like that that's very important, little things like that do come in handy. One other thing, and I'll wrap up with this, issue that comes up when using the grid rules are transferable skills. If you have a client that performs some type of skilled work, it could be any type of secretarial work, they had their own business, tax prep work, anything like that, work that was skilled, work that would take more than a short or brief demonstration to learn. The question then becomes, but let's say they performed it at a light or medium exertional level. Problem becomes is that they may learn skills from that job that would transfer down to a sedentary level. And if that happens, then the grid rules, you can't apply the grid rules. So it's very important that you understand what transferable skills are, and you also need to understand how to cross-examine the vocational expert on that. One quick tip is, again, with that SVP number. Always ask if the vocational expert does not give you, under direct examination, what that SVP number is. You need to ask for it, because let's say past relevant work, V says it's an SVP of 6. And then the judge says, are there transferable skills? And the V says yes, and here's the job, the sedentary job that it transfers to. You need to ask, okay, well, what's the SVP for that sedentary job? And if the vocational expert says, well, it's a higher skilled job, it's an SVP of 8, well, guess what? They can't do that. It doesn't work. The SVPs have to match, or the skills, the job where the skills are transferring down has to be lower. You can't transfer skills up from an SVP 7 to an SVP 8 or 9. So, like you can see, things have definitely changed as far as the Social Security cases go. In days past, it's just not quite as enough medical evidence going in and letting the judge decide. There's quite a few things that you need to do nowadays to be successful, especially in light of that, how I said at the outset, with allowance rates really dropping, with these judges being put under a lot of scrutiny. There's a lot of different little things that you can do. I want to leave the ALJ disposition information up right there, and that big case studies right there, just if anybody's interested in it. But I appreciate you all listening to me. I know if you're here more for the CLE hours, I apologize, because I know this can be quite boring at times. But anybody have any questions?
Do you have any specific comments on the worn out worker rule?
Actually, I've got the worn out worker rules in my materials. That is SSR 8263. And what the worn out worker rule is basically, if you have an individual, one, the person has to have marginal education and a long work experience of 35 years or more, and they have to be limited to the performance of arduous, unskilled physical labor which can no longer be performed because of a severe impairment. Don't see that as much as before because